reservation, which quite often, since what we can say from the day we enacted the constitution and came into force, reservation has always been a key point for discussions, and especially those who are correlated with the jurisprudence of service law as such. Maybe directly, indirectly, we all are the stakeholders in a different fashion, in a different way. And how that journey of the reservation has developed the judgments off the cuff which come into mind are Indra Sani, R.K. Sabharwal, then Nagraj, and latest judgment on Jarnail Singh was Lachhmi Narain Gupta. How the journey has developed and what are the facets of that would always be boggling in the mind of a common man, and especially in the legal fraternity. And when you speak of the reservation, or for that matter, any jurisprudence of law, one name which strikes straight away into the mind is that once the judgment comes and we feel that who can immediately actually embark upon that aspect and make it simple and simplified is one name, that is P.S. Rajagopal, who has come quite often on a platform. He is not only large-hearted, but the way he understands the things and makes it simplified is a nuance which will always be cherished to be understood. And the advanced, like in law, those who are connected with law, we say that there is a caveat filed. And so I had given him a caveat. At the end of the session, we would like to understand what is an Article 16, 16.4a, 16.4b, Article 335 of the Constitution of India. And at the same time, what is the way to understand and develop the art of critical thinking, analytical thinking, and what they say to understand the expansive understanding, literal understanding, and a textual understanding of any section or a law. So we will ask Sir to take the session forward, and at the end of the day, we will ask him, as we say in the writ petitions, it is respectfully prayed, we will ask him to show that nuances which he has himself understood, his associates have understood, but we would like to make that key open. Like I remembered in the childhood, we saw a movie as well as read a novel, Ali Baba, wherein said Khulja Sim Sim. So that formula we will learn from him. Over to you, sir.
Thank you, because it needs to be told at the threshold. Earlier, I used to rate a judgment critically only when I am to rely upon it in a court, or when I have to counter it in a court. But Vikas has now made me a faster student of law. I am grateful to him. Because exactly, I think on 28th January, this judgment was rendered. On 29th, I get a call from Vikas. Sir, you should speak on this. Then I told Vikas, give me some time to go through it. So that I gave next week, that is a second week of February. No. We would like to have your unadulterated views, because what happens is 1 week means so many critics would have come on the judgment. Then your thinking also might have been influenced with those critics. Therefore, we do not want that. You have to speak when nobody else has spoken. That is how I am here today. I am grateful to Vikas. This reservation journey, if we see, insofar as service jurisprudence is concerned, unlike reservation in educational institutions, the issues were, we felt, more or less settled until 1991. Then things started slowly moving, I don't say forward or backward. I simply say that things started moving. It became a dynamic concept. And Supreme Court had to strike a balance between what can be determined judicially and what cannot be determined judicially in the matter of reservations. This reservation is constitutionally enabled, but it is not constitutionally mandated. Between enablement and mandate, there is world of difference. When something is enabled, it is for the executive to exercise that power of that enabled power to introduce reservation. At the same time, it cannot be said that the judiciary has no role to play. Judiciary has a role to play to ensure whether or to adjudge whether the enabling power exercised by the government of the day has weakened the fabric of equality which runs through the Constitution of India in the chapter on fundamental rights. And it has to manage one more aspect, though not in chapter 3, that is Article 225, which speaks of administrative efficiency. Therefore, things started moving from 1990 onwards. The first awakening judgment was, till Indira Sahni, we were thinking that reservation means reservation not only at the threshold, but also in promotion. Then for the first time, Indira Sahni said that there cannot be reservation in promotion under Article 16(4). It can be only at the initial level of recruitment and not beyond. Then came R.K. Sabharwal, where R.K. Sabharwal said, to ensure the constitutional mandate of reservation not working as a discrimination, the roster should be linked to number of posts in the cadre. Of course, what is cadre? He need not be even an expert in service law. If you ask even any employee, he will say, sir, I am in workman cadre, I am in officer cadre, I am in manager cadre. Every working member of service knows what is cadre. Supreme Court said that you cannot treat the roster as a perennial source of reservation. When initial cadre strength is filled by operating the roster, thereafter replacement theory will operate. I do not find any difficulty in understanding R.K. Sabharwal, but it was a startling deviation from the past beliefs. Reservation was operating, then the roster was being worked as a perennial source, but nobody thought that there is a difference between vacancy and post. For the first time, Sabharwal brought out the concept of there being a vacancy without a post, and post and vacancy are different. They cannot be confused with each other. A slight deviation into the past before I go to the next judgment on the theory of this reservation. Way back, almost more than 40 years ago, Justice M. Ramajoyce, who was one of the tallest judges to have graced my High Court, that is Karnataka High Court. In one judgment, he wrote that roster can give you accelerated promotion, but it cannot give you accelerated seniority. That is, the seeds of catch-up rule are can be found in the judgment rendered by Lordship Justice Rajagopal. Thereafter, of course, we went by the length of service theory. That is, the date of entry into a cadre would determine the seniority. Ultimately, it fell on Punjab and Haryana High Court, where he became Chief Justice later. It is a coincidence that Justice Ramajoy did not render Virpal Singh Chauhan in Punjab High Court, but he did occupy Punjab High Court Chief Justice post at a later point of time. There it was said that roster promotion cannot give a consequential seniority. Then the things changed. To overcome Indira Sahni, 77th Amendment was introduced by introducing 16(4)(a). We thought that after 16(4), introduction of 16(4)(a), all confusion in reservation is over. But Ajit Singh II came. Ajit Singh II stated another amendment to the Constitution introducing 16(4)(b). Then consequential seniority. All these were concepts that evolved after 1990. Let us remember, from 1965 onwards almost, there is reservation in direct recruitment. In promotions, the reservation came in mid-70s. But almost for about 20 years after the advent of reservation, everything was stable. Then things started changing. That should then all these constitutional amendments came up for consideration in M. Nagaraj. I would say M. Nagaraj is a watershed insofar as law regarding reservation is concerned. M. Nagaraj reiterated that R.K. Sabharwal, the linking of roster with the cadre strength is necessary to keep extent of reservation within 50%. The second concept that was propounded by Nagaraj, which is most important for today's deliberation, is it said seniority is not a constitutional right. Loss of a few places in seniority would not violate Article 16(1). This concept of seniority, catch-up rule, all these things are not part of Article 16(1), but they are principles evolved in service jurisprudence by practices. Having said that much, he did not say that constitutional values of reservation have nothing to do with seniority. It did not say so. It added a rider that concept of seniority and all that has been evolved to maintain administrative efficiency. That created some problem. On the one hand, you say that seniority is not a fundamental right. You also say that seniority and catch-up rule are not constitutional concepts, but they are concepts evolved in service jurisprudence. And finally, you say that these concepts have been evolved with a view to maintain administrative efficiency. Then Nagaraj had a very, I can say, 2002, January 2002, the amendment to the constitution came, providing for the consequential seniority. Within 2 or 3 days after the notification of the constitutional amendment, Karnataka promulgated an ordinance providing for the consequential seniority. First writ petition in M. Nagaraj is filed by M. Nagaraj. Thereafter, several writ petitions came up under Article 32. Then the Constitution bench, having laid down certain guiding principles, said that all these state enactments giving consequential seniority, their constitutional validity shall be judged by the standards we have laid down in this judgment by the respective benches. I am referring to Nagaraj in little detail because Jarnail Singh too, in my humble opinion, has given a go-by to M. Nagaraj, which it sought to clarify. M. Nagaraj categorically held that these amendments to the Constitution have only given a guided power to the executive. It is not an unguided power. And the constitutional validity will have to be judged of the individual enactments on the anvil of what we have set out in paragraphs 201 to 204. In fact, they are very, 121 to 125. Today, by saying that Nagaraj will operate prospectively in Jarnail Singh too, are we saying that whether the state enactment is valid or not, the seniority gained up to date of decision in M. Nagaraj is protected? To my mind, it appears so, because ultimate reason given in Jarnail Singh 2 to declare that Nagaraj is prospective is several persons would have earned promotions, several persons would have acquired seniority. These things will be unsettled if Nagaraj is not applied prospectively. With due respect to learned judges who decided Jarnail Singh 2, giving judgment in M. Nagaraj a prospective effect in the matter of seniority, I am not saying in the matter of promotion. There is always a distinction in service jurisprudence between protecting a promotion and protecting a place in seniority list. By saying now that Nagaraj is prospective, particularly because it will unsettle the seniority, I think we have in our endeavor to clarify Nagaraj, I am sorry to say this, destroyed Nagaraj. I am not saying whether Nagaraj is correct or Jarnail Singh is correct or R.K. Sabharwal is correct. Ultimately, as advocates, we have to remember one thing, that when the Constitution bench decides something, till another Constitution bench reviews it, we are bound by. Seniority has never been held to be a right to be protected. I can tell only one example I can cite. State of Haryana was formed on 1st November 1966. Normally, all these seniority disputes, if you historically survey, it will be taken to Supreme Court either by engineers, as was done in M. Nagaraj, or by diploma holders and graduate engineers, as it happened in Sriloki Kosa, or in very rare cases, by direct recruits versus promoters. Even in that concept, it will be the engineers who will be engineering the litigation. I don't say that it is bad to engineer litigation, but they are the persons who drive the engine of litigation to settle the principles in these areas. In state of Haryana, as I was telling, it was formed on 1st November 1966. Seniority dispute traveled back and forth from Supreme Court to High Court to Supreme Court so many times. Ultimately, in the year 1995, kindly remember this, state was formed on 1st November 1966. Seniority Act was enacted, removing one by one the flaws pointed out in the earlier judgments of Supreme Court. Ultimately, in the year 1995, it gave retrospective effect to the extent of 30 years to the seniority law. It was challenged before the Supreme Court on several grounds, saying that after 30 years, no, you cannot touch my seniority. Ultimately, Supreme Court said, nobody has any vested right to seniority. They have only an interest in seniority. While promotion granted cannot be withdrawn by a legislation, seniority can always be changed. And Supreme Court upheld the 1995 Act of State of Haryana, subject only to one condition, that promotions already made shall not be disturbed. But future promotions will be governed by seniority that will determine under the 1995 Act. This judgment in SS Bola versus BD Sardana is also of a 3-judge bench. Nagaraj, we are clarifying. Nagaraj says seniority is not a fundamental right. Clarification says, since seniority is going to be altered, we declare it to be prospective. This is where some confusion has been created by this thing. Otherwise, look at the other findings given in Jarnail Singh too. It said, cadre should be the unit for measuring inadequacy of representation. It said inadequacy vis-a-vis the percentage reservation prescribed has to be seen in the cadre to which promotion is to be made. These are reiterations of R.K. Sabharwal. Then it also said, what should be the time cap for carry forward rule? We do not want to lay down anything. That again, some deviation from Nagaraj, because Nagaraj, this question came in Nagaraj about the time cap for carry forward. It referred to various service rules, and Supreme Court said most of the service rules stipulate 3 years as the time cap for carry forward. But it did not say that 3 years is the time limit. 3 years and beyond 3 years it will become unconstitutional. It did not say that, because it linked the extent of carry forward to the extent of public offices remaining vacant, thereby affecting adversely the administrative efficiency. That it stopped there. But it said later in the very same judgment that the constitutional validity of the individual state enactments will have to be judged on the basis of what we have stated above. Therefore, it gave a scope while judging the constitutional validity of the state enactments to say that suppose in a state there are carry forward for 20 years, 25 years like that, then perhaps it provided a wall to judicially correct. I entirely agree with the scheme that if persons who are eligible for reservation were not available on a particular day when the case came up for consideration for filling a promotional post, it should not be said that we will not carry forward. No, that would be snatching from one hand what we have given by the other, what the Constitution has given by the other. There should be a time cap. In Jarnail Singh 2, without deviating from Nagaraj, affirming Nagaraj, it said that it is not possible to lay down any time limit as a time cap. Then on the question of what should be the periodicity of review to determine adequacy of representation. This is spoken in the larger canvas of giving consequential seniority for the as a concept as a whole. Don't mistake it for not laying down a time limit for review in respect of a cadre, because cadre now the consequential seniority conferment in a cadre is well settled, and on that ground, Nagaraj, Jarnail Singh 1, Jarnail Singh 2, all are in unison. It is a cadre strength is the criteria, and the moment the envisaged percentage is reached in that cadre, you cannot further promote anybody to that cadre on the basis of consequential seniority. This is what I have understood. I may be wrong, but I have a feeling that I am right. In the matter of the consequential seniority as a concept, Jarnail Singh left it to the wisdom of the executive as to how long it has to be carried forward and all that, or at what intervals the review should take place. On that, nobody can quarrel, because it is for the executive to lay down the policy and not for the courts. Courts have only to interpret the law. Courts have to declare this is the limit up to which you can go, not beyond. It is said a judge is not a know-all. By wearing a wig and a gown, he does not become expert in all the fields. Gown and a wig do not give him a magic wand to behave as if he is an expert in all fields. His job is only like that of a referee. Blow the whistle if somebody plays foul. When the play resumes, you are not supposed to play. It is the executive which has to play. And in its English judgment, the court said that I think by a court of appeal, that is in Laker Airways. In this country, as the things stand today, aviation policy is laid down by the ministry and not by the court judges. Therefore, we stop here, and further travel is left to the executive. If they play foul or if the ball goes out of bounds, we are here to blow the whistle and nothing beyond. We are not to run the airlines, Laker Airways. Now, looking at that, we cannot take any exception to the answers given. First, it said, what is the yardstick one would arrive at quantifiable data showing inadequacy. Supreme Court said it is for the executive. We cannot lay down any norm for that. Then it said, what is the unit with respect to which quantifiable data showing inadequacy of representation is required to be collected? There it said cadre, because ultimately seniority is determined in a cadre. Promotion is given in a cadre. Roster is operated in a cadre. Therefore, inadequacy of representation, it has to be collected only cadre wise. It overruled BK Pavitra too. I know at least a few of the participants today are interested to know how it will affect their cases decided under Pavitra too. That is a matter on which I do not want to cogitate now, because shortly we may have to be crossing swords on that in the court of law. Therefore, one thing is letting out what is your defense, which has to be a guarded secret for every advocate. Yes, I speak, but I am also an advocate interested in my own profession also. Please remember. I do not want to say much on that. Then time period, it did not answer. It said it is for the executive to decide. Then one thing they answered was, whether they did not answer was whether adequate representation means proportional representation. This question has bogged the judiciary right from it came up even in Nagaraj, and earlier thought also this came up in Indra Sani, if I am not wrong. Yes, it came in so many times. There they said whether adequate representation means proportionate representation, proportionate to the population of a particular group. We are not, it is for the executive to decide. Now, I would also like to say something about the effect of leaving something to executive. When Indira Sani was pronounced, Indira Gandhi said that to justify reservation in favor of backward classes, there must be stipulation of a creamy layer. Then states, but what is creamy layer? It did not define. It left it to the states to determine what is creamy layer. I can tell you glorious examples. Why? See, what is happening is the days of statesmen is over long ago. Today we are having legislatures which look to the next election and not beyond. I am not saying this with reference to reservation alone, because I am a votary of reservation, and I have, in fact, in M. Nagaraj, when the enactment was, state enactment was referred back to the High Court, I was one of those who defended the 2002 Act of Karnataka State. And High Court accepted my arguments, and Act of 2002 granting consequential seniority in the state of Karnataka was upheld. The matter went to Supreme Court in BK Pavitravan, that was reversed. What I do as an advocate and what I feel as a senior member of the bar, these two are totally different. Now, if coming back to Indira Sani, states were to determine backwardness, the creamy layer. 3 years thereafter, some states still did not define creamy layer. When questioned by the Supreme Court, because one good thing about Indira Sahni was implementation of Indira Sahni was monitored by the creamy layer aspect. Some states went and said, we are not able to arrive at a decision as to what is creamy layer. Therefore, you decide. Supreme Court said, no, we cannot decide. It is for you to decide. Then they go back saying that we will decide. They never decide. Finally, in respect of this, Kerala, in the year 1996, Supreme Court had to appoint a committee. It is supposed to be done by the executive. The executive refuses to do. Then there is a case where Supreme Court appointed a committee headed by one of its ex-judges, Justice K.T. Thomas, who incidentally happens to be from Kerala, and he was also a very eminent judge of the Supreme Court. Backward class to identify creamy layer in Kerala, Supreme Court appointed a committee headed by Justice K.T. Thomas, requested the state government to extend its full cooperation. And after K.T. Thomas committee report came, creamy layer was defined. Because political executive was afraid that if we do not define, if we ourselves define, people who are out of creamy layer may be against us. People who are within the creamy layer also may be against us, because reservation, according to the political executive, is a divisive issue. It is not a unifying issue. And politically risky decisions, political executive does not want to take. At the same time, judiciary does not want to do it because they do not want to rule this. Same thing has come, I would say, in respect of these individual enactments, carry forward and all that. To be clear, I think these issues will be addressed by the Supreme Court while testing the validity of the state enactments, for which the matters have been directed to be posted by further hearing by 28 January 2022. All said and done, Jarnail Singh 2 is only an interim order. But the difficulty with this interim order is final order is required to be passed or commanded to be passed on the basis of this interim. That is the whole problem in analyzing Jarnail Singh 2. Therefore, friends, Jarnail Singh 2. Before I conclude, I want to add one more question. That was, see, for example, if we go back to Nagaraj said that economic backwardness. Nagaraj said backwardness has to be measured. Then Jarnail Singh 1 clarified it by saying the moment a caste or a tribe is included in scheduled castes or scheduled tribes under Articles 341 and 342, that itself is sufficient evidence to say that they are backward. Then they brought in a concept of creamy layer, even for scheduled castes and scheduled tribes. In Jarnail Singh 1, it said, when M. Nagaraj spoke of backwardness, it only meant application of creamy layer concept to the scheduled castes and scheduled tribes also in the matter of reservation. Therefore, for the first time, Jarnail Singh 1 introduced the concept of creamy layer. Therefore, creamy layer is going to be the one of the issues that I envisage to be hotly debated in judging the validity of the state enactments on the anvil of M. Nagaraj, as clarified by Jarnail Singh 1, as clarified Jarnail Singh 2. Therefore, Jarnail Singh is not end of the road. Even now, when debate in respect of any state enactments gets sufficiently loud and sufficiently hot, the chances of this matter again going back to a larger bench are not good. But it will not be larger than 5 judges because Jarnail Singh 1 has said Nagaraj is correct. There is no need to refer to a 7 judge bench. Therefore, this confusion is likely to persist. And that has been confounded by Jarnail Singh 2 by saying Nagaraj is prospective. When Nagaraj himself said that validity of all enactments that were before the Supreme Court in 2002 onwards petitions up to 2006 will have to be judged on the basis of Nagaraj test. That is efficiency, so many things they spoke of. Therefore, neither the advocates need feel that litigation has ended on these concepts because it has been clarified, nor the members of the service or what I say, employees, whether it is to whichever category we belong, irrespective of that. They also need not have a hope that this is though things have stabilized. According to me, Jarnail Singh 2 has only added certain destabilizing factors to the already fluid situation. Then I would conclude citing Ajit Singh 2, because in the matter of reservation, the concept of prospectivity was introduced for the first time by R.K. Sabharwal. R.K. Sabharwal gave a new interpretation to the operation of roster and said that however the interpretation we have placed would operate prospectively. The word would have, the phrase would operate prospectively came up for interpretation by a larger bench, that is in Ajit Singh 2, by a constitutional bench. What is prospective? There the Supreme Court said one paragraph which is very, very important when we try to understand the interpretation given to prospectivity by the Jarnail Singh 2. I'll just, that paragraph is titled Our Conclusion. There he said, there they said, what is the meaning of prospectivity of R.K. Sabharwal? Then Supreme Court said, it is axiomatic in service jurisprudence that any promotions made wrongly in excess of any quota are to be treated as ad hoc. This applies to reservation quota as much as it applies to direct recruits and promotee cases. If a court decides that in order only to remove hardship, this is the exact reason given in Jarnail Singh 2. To remove hardship, we are making it prospective. If court decides that in order only to remove hardship, such roster point promotees are not to face reversions, then it would, in our opinion, be necessary to hold, consistent with our interpretation of Article 14 and 16(1), that such promotees cannot plead for grant of any additional benefit of seniority flowing from a wrong application of the roster. In our view, while courts relieve immediate hardship arising out of a past illegality, courts cannot grant additional benefits like seniority, which have no element of immediate hardship. This is the categorical law declared in Ajit Singh 2. Yes, Ajit Singh 2 about consequential seniority has been now virtually set aside by virtue of a constitutional amendment, that is 85th amendment or so. But the concept of prospective overruling or prospectivity to remove immediate hardship, what is stated in para 89 of Ajit Singh 2 holds good even today. And another important aspect that appears to have been lost sight of in Jarnail Singh 2 is Jarnail Singh 1 lists about 12 judgments rendered by the Supreme Court following M. Nagaraj, including larger benches, where the 5-judge bench, then in IR Coelho, while testing the constitutional validity of Tamil Nadu enactment, Supreme Court followed M. Nagaraj. Now what happens? There are dozens of judgments rendered by the Supreme Court itself applying M. Nagaraj. Today, in the year 2002, you give prospectivity to a judgment rendered in the year 2006. What happens to the judicial determinations made in these 16 years? Are we unsettling the settled things? This prospectivity is invented on the ground that it will unsettle. If you do not give prospectivity, it will unsettle. What about the unsettlement that has taken place by your saying it is prospective? Therefore, I see hotter debates in courts of law on Jarnail Singh 2's prospectivity. I think I should conclude here because I thought I would complete within 45 minutes so that we will have adequate time for interaction. And Vikas had threatened me. Now, on to your threat, Vikas.
We knew that it would not be over in 45 minutes. It is as good as the lawyer saying it's my brief, but it runs into hundreds of pages. So we knew that once you are speaking, it has to be a threadbare discussion of the entire session. Yes. And actually, you have opened the new vistas for the mindsets to be opened. As they say that where there is a law, there is a flaw. So where there is a flaw, there has to be a lawyer. And that lawyer could be P.S. Rajagopal. But, if you want to give as we had discussed, the summary of the setup, what do you actually analyze? Meanwhile, I can say take the questions, because normally once we take it, people believe that it will be for 1 hour. No, so you can just give the insights in a bullet form.
What are the questions framed? First question framed was, what is the yardstick by which, according to Nagaraj, one would arrive at quantifiable data showing inadequacy of representation in public employment? It is not cadre-wise. Generally, there must be compelling circumstances, that is what is said. Then, to determine inadequacy of representation of SCs and STs in public employment, in para 16 of Jarnail Singh 2, Supreme Court said, no yardstick can be laid down by the court. That is, insofar as the introduction of reservation with consequential seniority, we do not want to lay down any norm. It is for the executive to decide. Then question number 2, what is the unit with respect to which quantifiable data showing inadequacy of representation is required to be collected? Then it said it has to be cadre-wise. What is a cadre? Cadre is defined as a part of service which is identified by law, by the state, as a separate unit. It separate unit means within the engineering cadres, junior engineer is a separate cadre, assistant engineer is a separate cadre, assistant executive engineer is separate cadre. There again, assistant executive engineer electrical is different from assistant executive engineer civil. The simple test as to whether something constitutes a cadre or not is whether the posts are interchangeable. This is the test laid down in Chakradhar Pass form. If you go back to a few years, there were 3 posts of Joint Directors of Indian Medicine and 1 post of Director Indian Medicine in Bihar. The Joint Directors posts were designated as Joint Director Unani, Joint Director Ayurveda, Joint Director Homeopathy. For each of these posts, qualifications were different. Only a Deputy Director Unani can become Joint Director Unani. A Deputy Director Ayurveda cannot become Joint Director Homeopathy. There the Supreme Court propounded the theory of interchangeability. Unless the 2 posts are interchangeable, you cannot call it a cadre. That is the simplest way to understand the meaning of a cadre. There were later on High Court of Karnataka, it said, following Chakradhar Pass form, a lecturer in English and lecturer in Kannada are not interchangeable. Therefore, each is a separate cadre. That concept has been reiterated in answer to question number 2. Then question number 3 was whether proportion of the population of SCs and STs to the population of India should be taken as the test to determine adequacy of representation. That is, whether proportional representation and adequate representation are one and the same. What do you mean by adequate representation? Whether it is proportionate representation. Answer side, the answer of the Supreme Court is, we do not want to answer this question. It is for the executive to formulate its view. Should there be a time limit for reviewing inadequacy of representation? Supreme Court said it has to be periodically reviewed. But at what intervals, we cannot say. It is for the executive to decide. 5th question is whether the judgment in M. Nagaraj can be said to operate prospectively. That is the main thing of my discussion today. Therefore, prospectivity, it said yes. Then whether quantifiable data showing inadequacy of representation can be collected on the basis of sampling methods as held by this court in B.K. Pavitra 2. No is the answer at para 47 of the judgment. These are the 6 questions and 2 answers, I would say. One answer I entirely agree. One answer, whether I agree or not, is different, but it is likely to unsettle certain things, and prospectivity is something that is going to be cause for major judicial debates in next 1 or 2 years. Yes, have I summed up Jarnail Singh?
Perfect.
68 paragraphs are यार उसमें ज़्यादा नहीं है summing up करने के लिए.
So, reverting back to what I was saying, for a young lawyers and for a very young lawyer like me, how do you say that? How should one develop the art of critical thinking of a judgment?
See, critical thinking is something not only for lawyers, for everybody. We should stop accepting a thing as correct without posing this question to ourselves. Let me test this conclusion. Suppose Supreme Court in a given case draws some conclusions. The critical way to test the correctness is whether something else could not have been the correct answer. Because judges have some limitations. Of course, that also has been given up in Jarnail Singh too. They are bound to follow larger bench decision. Whereas an advocate is not bound to respect any decision. He is kindly remember this power. He is the only citizen in this country who has power to criticize the government, but within certain norms. When we realize that we are more powerful than judges, because a High Court judge cannot comment on Supreme Court judgment, whereas a High Court advocate can say that, please do not follow it, is a wrong thing. First and foremost, advocate, whether young or old, should realize he is the most powerful person in dispensation of justice. Remember another thing. If we do not criticize, if we do not propound an alternate viewpoint, law would not have developed. Constitution would not have become such a vibrant document, but for you and me. You and me means every advocate who lives the life of an advocate, who has the fearlessness of the advocate, and who remembers that he is the person making the law, neither the parliament nor the judges. Because judgment is rendered on the assistance given by advocates. It is initiative to propound an alternate viewpoint should emanate from the advocate. He is the moving force. If you read para 68 and say that this is the law laid down, my lords, and if it is convenient to me, I may read that judgment. My opponent should say that para 68, my lords, is contrary to Ajit Singh too. Only then law will develop. Somebody has to point out, look, object of the judgment is to see that settled things are not unsettled. Look what is the unsettling effect it has brought up. Then persuade that hold it per inquiry or refer to a larger bench. It is not that advocates are only like any other actor in the system of justice dispensation. I would say advocates are number one and most critical part of justice delivery system. In courts of law, we only call the judges as lords. Only we are called as learned advocates. That learning should be coupled with courage. Courage to test is what is required. Once you have that courage to test, courage, the mind to analyze will open up. Not that intellectually we are shrunk. Intellect refuses to blossom more out of our fear. Overcome the fear. Where the head is held so high. Go back to that tradition. I may not say that every finding is wrong. Apart from the case we handle, apart from thinking whether this argument fits into my case, think as an independent person of law that there can be a better view of things. Of course, don't propagate that better view in the court if it is against you. Wait for appropriate case to propagate that better view. Like otherwise what happens? I appear for the defense in a dismissal case of an employee and say that, my lords, for the misconduct he has committed, this appears to be correct punishment. If I say that, whom am I defending? I am not defending anybody. Therefore, you should have the courage to argue an unpopular argument or an argument which others may find it will not be accepted, with the confidence that one day you will make it acceptable. One day you will make it acceptable. That is the confidence with which you have to move. It is confidence which creates creativity. And I am having abundant confidence in particularly younger advocates, not as young as Vikas, little more younger or little less younger than him. They have the wherewithal to analyze and come up with massive solutions, which people of our age would never have thought of it. With every new advocate entering the profession, I feel that a new dynamite of thinking is added to the argument. Only thing is, our thinking capacity is shrunk by our fears. So if I have to say, answer question of Vikas, be bold. If you are destined to lose, you will lose a case. But you would still have made some mind start thinking that your viewpoint will be correct and the judgment may be wrong. Have I answered, Vikas?
I've understood what we always hear about, that it is how you think about the prism, or what we say that whether it is a half glass empty or half glass full, the spirit and the continuation and that spirit to move on, that this glass is full. And if you are representing the other side, you can always say it's half glass empty.
Yes.
So it's the reflection, or what and what Shakespeare said, that nothing is good or bad, but your thinking makes it so, or your company makes it so. And you have also demonstrated that it is only the expansive of the mind. The flower continues to remain the same, but once it is a flower, it's a flower. But once it's a cauliflower, it's an entirely different game. So in fact, the way you expounded the theory, the way you told us on various sessions, sometimes I feel that we should just have a Q&A form where we understand how to take what I was. The next question, I will not be taking 2-3 questions which have come on the platform, because I feel that if the youngsters can be, or for that matter, any part of the society can be encouraged. Like these are 400 pages, now these are 68 pages running. How do you go that extensive study, despite the fact you are so busy, or for that matter, any good lawyer? They say what the difference between a lawyer and a senior lawyer is that ordinary and the extraordinary effort, and you have told that your extraordinary thinking should be there, and that hunger to actually achieve better things, what other people didn't have, that whispers of thinking. So how do you develop that art, like reading 300 pages in a day? You are also hard pressed, for that matter, for any professional who is working hard. How to build that reading habit of understanding the things from 300 pages, you sieve out the things. As they say that in the entire milk, the cream comes on the top. So how do you bring the cream out of that entire judgment, or any analogy?
I do not have any.
I'm saying in general. I'm not saying.
Generally,
so I know that you can do that. You whip the cream out of the entire milk.
One important aspect of reading a judgment is we should not read head notes to the extent possible. Now we have this access to internet, where if a judgment is pronounced today, tomorrow it will be on SCC online without head note. Or today itself you can get on live law, or today itself you can get on the SCC website itself, latest judgments. Before they are head noted, read the judgment, because you will be reading the textbook. Judgment without head note is a textbook. Judgments head noted is Allahabad Law Series 30 questions. You know the difference between 30 questions lawyer and a textbook lawyer. Therefore, I would prefer to read, particularly this present situation of COVID for the last 2 years or slightly more. It has given this access and time to us to read unhead noted judgments. If you read unhead noted judgments, your understanding of the judgment would be much better, because there will be nobody to guide you. Go to this paragraph, this is what it is said. For example, these head notes can be so confusing and so misleading. P.R. Ramakrishna or something like that, one judgment is there, where it was one of the parties was National Textile Corporation. The question of rights of workmen came. Is discussed there in a winding of proceedings. What is the right of a workman trade union to participate? Head note says that if a right is not denied to a workman by law, it is granting that right. I relied on that head note and succeeded also in one case. Then one day I developed, let me see where is that paragraph. There is nothing even closer to that head note in the entire judgment. And you will be aghast. That judgment was upheld by Supreme Court also, which I read that head note here and succeeded. It was upheld by Supreme Court also. Therefore, first thing is, we are all beyond 18 years. We are majors. I am closer to I am beyond 70 also. That is a different. Let us learn to read without a guide. At the high school level, guided teaching should be over. If our advocates develop reading the judgment in full, covering or without looking at the head notes, we will be a better law. But ignoring the head notes is difficult, because shortcut is always a trick. And we pretend we have no time to read the full judgment. Tell me the head note, which is the paragraph I have to go. You go and we falter. Therefore, now that we have access to unhead noted judgments, read those judgments. Then if you want to see whether your understanding is correct or if you have missed any point, then you go to SEC. Unfortunately, this SEC head noting, yes, it is good, but it has killed our instinctive understanding of the judgment. Having a guide is sometimes a disincentive for learning. And reading 60 paragraphs or 70 paragraphs is not something difficult. Yes, if it is something beyond 100 paragraphs, we will have to be reading it like a serial. And that becomes difficult unless you want to, unless there is a pressing case where you have to rely on that, you will not be reading. But up to 100 paragraphs, reading is easy if you avoid reading head notes. That is how I have developed morning after reading the headlines in the newspapers. Newspapers, I read only headlines. But judgments, I ignore headlines and read the report as it is. There we have to draw a distinction, where to read head notes, where to headlines, and where to read substance. Judgments always read substance and not edits. It is time consuming. Of all, yes, if we don't read, what else we are doing? Advocates are doing only two things: reading and talking. Talking in how we do. Talking के लिए preparation is reading.
So you have actually explained that reading the head notes would be putting like the cart before the horse. So you should always put the horse before after the cart. And unfiltered, even otherwise they say that even in the nowadays cameras, your children also tell that it's a filtered photograph or an unfiltered photograph. So you say that the best way to understand things are to have the unfiltered view and then go by the art of filtration. And that's what they say, that even for the becoming any good thing, you have to understand the art of pyramid. The way from your home, you start with a solid base, and by the end of the day, the best things come forward. And as you rightly explained, that even the bow goes through the highest distance if you pull it back and then push it forward. So thank you, sir. It has always been an enlightening session. And be that as it may, I take the commitment that we will have the art of advocacy or reading, etc. from you. Now, this thing at least I can take. I've been able to vouch upon that fact that whenever we have been made a request, you have always been kind enough to make us understand the things. And before we part for today, tomorrow the session would be power of magistrate to direct investigations under the section 156(3) CRPC. To have a different prisms in a different perspective, every lawyer has, as Mr. P.S. Rajagopal has made us understand. So he's by C.S. Manishankar, a senior advocate from Madras High Court. And as Sir said that nothing is permanent except the change. And that's what we have all understood from him, whatever we have understood today. Thank you, everyone. Stay blessed, stay safe.
Thank you very much.